Attorney Kip from Malek. Today I'm going to be talking about light duty job offers. So in the workers' comp world, there's two ways you're entitled to temporary total disability compensation. One basis is your doctor has taken you off work completely in a Medco 14. The other instance where you may be entitled to compensation is if you have your doctor has released you to work with restrictions, but your employer is not able to accommodate those restrictions. In that instance, you would still be entitled to temporary total disability compensation. But what happens if your doctor has released you to work with restrictions and your doctor gives you a light duty job offer? Light duty job offer that accommodates your physical restrictions. It's within reasonable proximity to your home. What happens in the instance where you have other obligations that make it so you cannot undertake that light duty job offer? And specifically, let's say it's a work shift issue. So let's say you worked the day shift because you have to be at home at night to take care of your kids, and you couldn't work the night shift because working night shift, you just couldn't. Your kids can't be at home by themselves, okay? Or conversely, you work the night shift so that you can take care of your grandchildren or something during the day, and you need to take care of your grandchildren. So the question is, what do you do in that instance? The Supreme Court has had a recent case that has arisen, and this case is called Ryan versus Moss, and in this case, it was a grandmother who worked third shift, and she was released to work with restrictions. The work gave her a light duty job offer. It accommodated the physical restrictions. That's important. If it doesn't, if the work restrictions say you can't walk, and the light duty job offer basically involves walking across a warehouse, that's not a reasonable light duty job offer. You couldn't do it, okay? But in this instance, in this case, it was the lady worked night shift. They wanted her to do day shift. She couldn't do day shift because she took care of her granddaughter during the day, and so she thought she had a good faith reason for refusing the job offer. And then the Industrial Commission, the DHO denied it. The SHO allowed comp. They said, hey, she's entitled to comp because she has a good faith reason, and maybe it wasn't made in good faith by the employer. It went to the employer appealed and went to the 10th district. I think the 10th district, maybe it said, no, she's not entitled. And then I was appealed to the Supreme Court, and that's where this case comes from. So the Supreme Court said there's no refusing on a good faith. You the injured worker cannot make an argument that I'm refusing this job offer. I'm offering a good faith refusal of the job offer. The Supreme Court said there's nothing in the statute that addresses that. The only analysis is whether that job offer is made in good faith by the employer. What's good faith? The Supreme Court says good faith is basically got to be determined by the Industrial Commission. It's a factual thing. We're not going to determine what good faith means. We're not going to define the edges of the fences, the squared within which good faith sits. We're going to leave that determination to the Industrial Commission. But good faith could be, and this is an example where good faith might not exist, where rather it might be bad faith. It would be a bad faith job offer by the employer, that they made an offer that they know the employee couldn't take. So in this instance, let's say the employer 100% knows that there's no way that this person could work first shift because she has this obligation to deal with her kid. She has to take care of her granddaughter during the day. If the Industrial Commission, and again, they're the fact finder, if the Industrial Commission determined that the employer knew that the injured worker couldn't work first shift, they can only work this night shift, and they couldn't work during the day shift. If the employer knew that, and by knowing that, they know that the employee would not be able to take it, that would be a job offer made in bad faith, and therefore that would be it's a bad faith job offer. If the injured worker doesn't take that bad faith job offer, then they would be entitled to workers' compensation. Okay, so but in that case, the Supreme Court said, okay, we're going to bounce this issue, whether that was a bad faith or a good faith job offer, back to the Industrial Commission. They're going to figure it out, and whatever they decide is the decision. And that's the weird thing is one hearing officer might find that, hey, that's a good faith offer, or we don't find that the employer knew about this. Another hearing officer might find that that was a bad faith offer, and hey, the employer knew that she had this obligation during the day she couldn't take. So that's kind of the roll of the dice for the hearing officers. But that is one area of law, this work restrictions and when is good faith and bad faith. If you run into this instance and you're not represented, I absolutely 100% recommend that you find a workers' comp attorney, run the scenario by them, get them involved, hire somebody to represent you, because this is scenarios where you could burn yourself really quickly. And what might happen is you don't take the job offer, and when you're not entitled to comp, you might still not be able to go back to work all ready. You might still have significant work restrictions. You're not, and if they find that was a good faith job offer by the employer, and you refuse it, you're not entitled to temporary total disability compensation. So you're not only working, you're not getting wages, but you're not getting temporary total disability. You're not able to. I mean, how do you fix that? I mean, you try to work sometime, but when you find another job, maybe you could find one, maybe you couldn't. But you gotta be really. There's a lot of these pitfalls that you can run into with these workers' comp claims. So don't mess around. Get a workers' comp attorney involved. There's either you call us, you run your situation by us. If we think you need to get us involved, we'll help you. Otherwise, you can run it by any number of workers' comp. Anybody who does this, who's been in business for years, like our law firm, is going to know the ins and outs. They're going to know what you need to do, and they'll either be able to help you or they won't. But it really makes sense to run your legal situation by an attorney rather than trying to do it on your own. Do not mess around with these workers' comp. I see it time and time again where an injured worker has gone things on a pro se basis by themselves and have gotten into scenarios that were 100% avoidable. Okay. And there's Supreme Court cases and 10th District cases replete with circumstances where an injured worker has gotten burned by procedure. There's some procedural thing that they didn't adhere to, and then that screwed them up. Screwed them out of either getting their claim allowed, getting comp, or getting some kind of treatment. So with that being said, if you have any questions, concerns about anything that I've talked about, give me a call, give me an email. Appreciate you listening to this video. Until the next video, I wish you good luck. No new work injuries, no work injuries. Stay healthy. Thanks. Bye.